Okay, good morning, everybody. I think we'll make a start. There are a number of people yet to join us, but I'm keen to ensure that we stick to the timescales that we have given to you. So today's webinar is regarding how to deal with collective redundancies. I'm anticipating this to last approximately an hour and a half, including questions and answers. In terms of housekeeping, you'll see that you're all muted currently. If you could stay on mute, please. By all means, feel free to put your video on if you want to have your video on. Sometimes it helps me to see the people I'm actually talking to. So please do share your video if you wish to. I'm hoping that we'll save questions and answers until the end, because we do have quite a lot to get through. However, if you have a particular question on a particular slide that you feel is really important that you'd like to ask at that point in time, please do raise your hand, and my colleague Kane, who is co-hosting this, will unmute you and allow you to ask the question. But as I say, if we can avoid too many interruptions as we go through, because I'm keen to ensure that you get through all the slides, and then we can deal with any burning questions you've got. By all means, send questions as we go along to Kane, and she will store those questions up and then raise them at the end on your behalf, and we'll talk through those questions that you've raised. Okay, so we'll make a start. I don't think I need to make any introductions to who I am, because most of the people on the webinar today I know. But the thing I would like to just set out is what we're going to cover today. And ideally, at the end of today, you will hopefully understand why it's important to comply with collective consultation and what the consequences of a breach are. You'll also understand, when does the obligation to collectively consult arise? Who do you need to be informing and consulting with? What is involved in the consultation process? Are there any defences to a breach of the regulations? And what is the position in relation to collective consultation in this COVID-19 pandemic? So hopefully at the end of this session, you'll be able to, or you'll understand a lot more about those areas. Okay, so firstly, why bother? What is the risk to you as a business if you don't comply with the collective consultation regulations? And I thought I'd start with this because it really will emphasize the importance of fulfilling your statutory obligations. So let's take an example. An employer has to make 70 redundancies from a headcount of 250 at their head office. The average salary per employee is £30,000. And for whatever reason, the employer fails completely to comply with their collective consultation regulations. Let's just say they completely weren't aware of it. So the case of Susie Radin Limited, 2004, confirms that the protective award that is payable for a breach of collective consultation should be seen more as a sanction, a penalty for a failure to comply. And so the starting point for a tribunal when making an award is 90 days pay. So looking at this particular example, average salary of £30,000, 90 days pay has an approximate value of £7,500 per average employee. So if you times that by 70 people who were made redundant, you come out with £525,000. However, that's just the people who are made redundant. The regulations go far further than that, and they apply to all affected employees. So let's assume all 250 staff are affected employees, then the value of that protective award claim gets to £1.875 million. And it's that risk here that really is something you need to bear in mind when you're deciding to what extent, well, number one, do you comply with the regulations? And if so, to what extent? And do you cut any corners? And it's quite a useful point, because I was actually on a conversation with a client yesterday, and we were talking around 2 batches of dismissals taking place within a 90-day period. The first batch being around 70 staff, the second batch being around 50 staff. But that would take the number of dismissals over 100 and result in the need for 45 days consultation. Yet we haven't started with the second batch, and we've only started 30 days consultation with the first batch of employees. And the conversation I had with the client was quite simple. For the sake of extending that first batch of consultation by 2 weeks' pay and the associated cost of wages, how does that compare to the potential liability of failing to comply with your obligations? And the client did the calculations, and we were looking at a potential liability of 2.8 million compared to a cost of wages of £90,000. So that is going to drive their decision making when they decide to what extent they comply with collective consultation. So, just a bit of background to the legislation. This legislation has been in some shape or form in existence since 1975, both in UK domestic legislation, but it derives from an EU directive. So this is led by the European Union, the legislation that they've put in place, and because of our membership of the European Union, the UK have implemented domestic legislation to comply. The legislation, however, has taken a significant amount of change in the 1990s, and we now have the current legislation in place, which is the Trade Union Labour Relations Consolidation Act 1992. That's a bit of a mouthful, but we call it TULRCA for short. And the relevant part of TULRCA, which is a significant piece of legislation, is Chapter 2, Section 188 to Section 198B of those regulations. So that's the regulations that set out our obligations. And a very quick summary of what your obligations are. So Section 188 applies when 20 or more dismissals are proposed at any one establishment within a 90-day period. If the regulations are crystallised, or the obligations are crystallised, then you must consult with a recognised trade union or elected employee representatives. There are minimum time limits for consultation of 30 days for up to 99 dismissals and 45 days for 100 or more. And you're going to have to consult on mandatory areas, including avoiding redundancies, reducing the number of redundancies, and mitigating the consequences of redundancies. Now, that's a really brief summary and goes nowhere near into the detail of how the regulations apply and some of the complexities that arise. So I think to do that, I want to take a look at what the actual wording of Section 188 says. And I've put it here on the screen for you. And you can see I will have highlighted in a maroon colour and in italics the key words that we need to pick out and which we'll explore in more detail as we go through today's session. So we're going to have a look at proposing, dismiss as redundant, the meaning of an establishment, 90 days or less, appropriate representatives, who are affected employees. And then we'll also look at Section 188.2 as to what does it mean when it says consultation should begin in good time. We'll look at the numbers of employees affected and staggered dismissals, and also what we mean by a dismissal. So, and just to read through the Section 188, it does say where an employer is proposing to dismiss as redundant 20 or more employees at one establishment within a period of 90 days or less, the employer shall consult about the dismissals all persons who are appropriate representatives of the employees who may be affected by the proposed dismissals or may be affected by measures taken in connection with those dismissals. So just on that latter point about measures taken in connection with those dismissals, and that initial example I gave at the outset, 70 people proposed to be dismissed with a head count of 250 at head office, the reality is that those dismissals of 70 people are likely going to have an impact on the remaining 180 people, because they may well have to absorb additional duties or responsibilities. So their job role may well change, and therefore they are affected by the measures of the dismissals. So they are caught by this legislation. It's not just the individuals that we will be making redundant. So looking at that legislation and the wording of Section 188A in particular, firstly, what do we mean by employer? Well, an employer is a legal person by whom the employee is employed, and that's defined by Section 295 of TULRCA. It is a distinct legal entity. So if you've got group companies and each company within the group are a separate legal entity, even if they are based at the same geographical location. And so if we've got group companies, but with different companies based in that one location, and you've got multiple redundancies across each company in the group, you do not need to aggregate them. You can treat them as distinct legal entities, as a separate employer, and decide whether or not the collective consultation obligations apply. In terms of who is an employee, well, the regulations say it's a person who has entered into or works under a contract of employment. The definition of employment contract is not defined in the regulations, but it is assumed that the usual common law test as to employment status applies. We believe that the definition can be wide enough to capture those individuals who have accepted a job offer, but are faced with the job offer being withdrawn. So if you're going through a headcount reduction on a collective redundancy basis, and part and parcel of your strategy is to withdraw all job offers that have been accepted, then they should, in theory, be included in the consultation process, and a failure to do so may be a breach. Also, the definition of employee excludes fixed-term contract employees where their contracts will expire naturally. It will not extend to fixed-term, so where fixed-term contract employees' employment contract is brought to an end earlier than the expiry, then they will be caught. So again, you need to have a look at the makeup of the individuals that are affected by your proposals and decide, are they employees? What kind of employee are they? Are they on a fixed term contract? When will that end? Are we ending it early? Have we offered jobs to anyone that have accepted those job offers that we need to include in this consultation process? So tip there, identify who is the employer of the affected individuals, particularly if you're in a group. And secondly, review the status of all individuals affected. So when does the duty begin? Well, go back to section 188. It says when you're proposing to dismiss as redundant 20 or more individuals at one establishment in a 90-day period or less. That's when the duty will crystallize, and we're just going to have a look at each of those in turn. So what do we mean by proposing to dismiss? And this is quite difficult, and the case law is a little bit grey. What we do know is it's less than a decision, but more than a mere contemplation. And it needs to, you need to be able to commence consultation so that it begins in good time, that it's early enough to enable meaningful consultation, and that the employer still has an open mind as to the potential outcome. So looking at that, it's somewhere between being a mere possibility and a clear provisional intention. So whilst proposals are at a formative stage, the argument is that the obligation hasn't crystallized, but once it starts gathering a bit of momentum and it becomes more than just a contemplation and more of a distinct possibility, then at that point in time, the obligation to consult may well have triggered. And I think it's around this area that a lot of employers potentially run the risk of falling foul of the collective consultation regulations, because lots of clients come to myself and my colleagues in the team and say, oh, we need to make sort of 40 people redundant within the next sort of 90 days. Well, they've already made the decision that they need to make 90 people redundant. And one of the obligations of collective consultation is to consult on ways of avoiding redundancies. So there is an argument that our thought process in leading up to the need to reduce headcount has gone beyond the point of being a mere proposal but through to a point where we've committed to a headcount reduction. And that leaves yourself open to a potential challenge from any union or employee representatives that you've delayed the start of collective consultation to the point where consultation or the obligation to engage in meaningful consultation can no longer be fulfilled, and so in breach of the regulations. And just having a look at this case of Unison against Leicestershire County Council, in this particular case, an employment tribunal found that the council had breached section 188 by failing to consult when it sought to make changes to its employees' contracts by dismissal and re-engagement. The council argued that no duty to consult arose until the council members had approved the plan to dismiss and re-engage the staff. The tribunal considered this argument, but held that it was a flawed argument and that the obligation to consult arose before the decision to dismiss had been taken. In any event, the tribunal ruled that the decision had in fact been taken by the council's management a month before the formal approval by the board, and as such, there was a failure to comply with the obligation to consult meaningfully. This decision was upheld by the Employment Appeals Tribunal as well. So it's just really re-emphasising the point that consultation needs to begin before you've made decisions. And I do worry that lots of clients allow that sort of strategic thought process around people planning to go too far to the point that you're leaving yourself susceptible to challenge. So let's just have a look at that in terms of a case study. So ABC Limited employs 150 staff across 2 sites and is struggling financially due to COVID-19. It knows that it's likely that it will need to make more than 30 redundancies over the next few months. However, it hasn't yet finalised the precise number of roles that are at risk of redundancy, nor does it know which site or departments in the redundancies will take place in. ABC is the view that it does not yet have enough information available to carry out meaningful consultation. And the question is, has ABC Limited comply with their duty as the obligation to consult crystallise at that point in time? My view is that it hasn't yet crystallised, and the reason being is they haven't yet sort of drilled down into where the redundancy is going to take place, at which sites those redundancies will take place, and also the likely numbers of roles that are going to be affected. It's still a little bit at the formative stage. And to support this sort of case study, the case of MSF against Refuge Assurance upheld this position. And essentially they confirmed that an employer's decision-making process must be sufficiently well advanced to have identified that over 20 employees at one establishment will be dismissed as redundant within a 90-day period. I think the best piece of advice I can give to you is when we start talking about headcount reduction in an organisation, as soon as we start thinking about 20 or more redundancies at one site, it's at that point you want to be taking legal advice as to whether or not your obligation to consult has now arisen, and you need to start thinking about getting that off the ground. Just a couple of other examples here just for your benefit as well. The Keeping Kids Company against Smith and others. This held that the duty to collectively consult crystallised when there was a proposal that might have affected any or all of the employees. The tribunal held that the employer had a clear, albeit provisional, intention to dismiss employees as redundant, and so the duty to consult crystallised at that point. The case of Scottish Premier Meats Limited, in this case the company was in financial difficulties, which led the employer to decide to either sell the business as a going concern or to close it down. But if there was going to be a site closure or close the business down, that would have led to 155 redundancies. The company decided to initiate a voluntary redundancy program, but the employees were not told about the possibility of selling the business. When the remainder of the employees were subsequently dismissed without consultation, a claim for a failure to collectively consult under TULRCA was brought. In this case, the Employment Appeals Tribunal upheld the tribunal's decision that on these particular facts, the employer had formed a proposal to dismiss as 20 or more people as redundant when it's considered either selling the business or making redundancies. So the fact that there was an alternative course of action did not prevent the obligations crystallizing. And I think that's important because lots of clients sometimes come to me and say, well, we're thinking about this amount of potential redundancies, but there are some alternatives in the mix which might affect the numbers. But if the numbers are more than 20 and it's a potential distinct alternative outcome, then I think you need to be thinking about starting collective consultation. What do we mean by dismiss as redundant? So we've had a look at proposing being part and part of this. When does the obligation to consult crystallize? The other element is to dismiss as redundant. this covers quite a wide range of situations, and obviously it covers the standard definition of redundancy, which is where the job is disappearing, the workplace is disappearing, or fewer employees are needed to carry out a particular role. However, the Tulrecher definition of redundancy goes much further than the definition in the Employment Rights Act. And essentially, it states that any dismissal which is through no fault of the individual is caught by that definition. So what do we mean by a no-fault dismissal? A good example would be where we are looking to change terms and conditions of employment. We can't get the agreements of the individuals involved, and we're therefore looking at a termination and re-engagement process. Here, the employee's role is being terminated, or their job is being terminated through no fault of their own, and therefore that is caught by the definition. So too are voluntary redundancies. It's still a dismissal. So too are exiting people via a settlement agreement. That again is potentially a no-fault dismissal, particularly if the cause of the reason behind the exit under the settlement agreement is anything other than misconduct or capability. There isn't another reason for it. And I'm just reminding you at the bottom there, it does not extend to the expiry of fixed-term contracts. They are outside the definition of dismissal. So just giving an example on that, you wish to change the terms and conditions of the employee's contracts of employment, but they refuse to agree to the new terms. So one of the options when they refuse to agree to the new terms is to obviously impose those terms unilaterally, but you run the risk of significant claims for constructive unfair dismissal, particularly if the changes are fundamental. Another option will be to grab the bull by the horns and to go through a termination and offer of re-employment route. And in those scenarios where 20 or more employees are affected, then the regulations are engaged and you must collectively consult on the changes to the terms and conditions that you're seeking to get agreed. Now, just on this point, I mentioned the possibility of imposing unilaterally the sort of terms and conditions on these employees. Whilst that is a possibility, the risk obviously is constructive unfair dismissal claims, but I am aware of case law that has gone through which has confirmed that a collective unilateral imposition of changes to terms and conditions which results in employees asserting that they've been constructively unfairly dismissed is still caught by the regulations. So you still need to inform and consult before you unilaterally impose terms and conditions of employment. Another thing just to consider in relation to proposing to dismiss 20 or more. So quite often, I'll give you an example. I'm currently acting for a school which is going through a process of changing the terms and conditions of employment of its teaching staff in relation to its participation in the teachers' pension scheme. It wishes to come out of the teachers' pension scheme and change the level of contributions that are being made. We could have, if we thought there was any benefit in doing so, we could have started off a process of informal discussion with employees to see how many employees would voluntarily sign up to the new terms of employment. And at the end of that sort of voluntary informal approach, we could then determine how many people are resistant to change. Is that more than 20 or not? Are the collective consultation obligations crystallized? So tactically, you could go through an informal process of trying to get people on board to agree to the new changes with a hope of getting the number of people you to dismiss, or 20, with this school. The number of dismissals below 20. So the next part of this section 188 consideration is 20 or more dismissals at one establishment. And what do we mean by one establishment? And, you know, sort of if you're as old as I am, you'll remember actually going into Woolworths and buying your penny sweets or your CDs or even records in those days. Obviously, Woolworths went into administration in or around 2010, along with Ethel Austin. And as a result, all the people employed by Woolworths and Ethel Austin were made redundant. And the union pursued a claim for a failure to inform and consult with all redundant staff, and sought a protective award for all the redundant employees. And the issue for the courts to establish was whether or not each branch, each store was one establishment, or would you look at the Woolworths as, the entirety of Woolworths as one establishment? The union were arguing the latter. Woolworths, or the administrators and the Secretary of State, because the Secretary of State got involved, were arguing that each store was a separate establishment. And this was important because the majority of stores had less than 20 employees in it, and it would have reduced the liability significantly for the administrators sort of administering the insolvent estate. So the good thing about this case is it's made things a lot clearer. And in particular, the case law went from the Employment Tribunal, which upheld the decision that each store was a separate establishment. It then went to the Employment Appeals Tribunal when the unions appealed, and the Employment Appeals Tribunal confirmed that they believed Woolworths was one establishment as a whole, and that each store was not a separate establishment. And then Woolworths, or the administrators, appealed, and the Secretary of State was joined as part and parcel of the appeal. And rather than the Court of Appeal dealing with it, they referred it to the European Court of Justice to decide on the meaning of an establishment under the EU directive, which, as I say, has direct effect onto the UK regulations. And the pleasing thing for employers is that we got that much needed clarity on this issue. I recall advising JJB Sports PLC on their headcount reduction across their store portfolio in 2009, 2010, and this decision hadn't gone through, so we were having to take a decision based on our own interpretation of the regulations, and we've gone along with the Woolworths approach of treating each store as a separate establishment. And thankfully, this case law made its way through to the ECJ, and they confirmed that each store was indeed a separate establishment. So, taking the key points from that decision, this is what we need to be considering when determining what an establishment is. So looking at where the redundancies are being proposed, are they being proposed, is the place of work, or is the establishment a distinct entity or unit to which employees or workers are assigned to work? Does that unit or that entity have a certain degree of permanence and stability? Does the workforce have the technical means and certain organizational structure to allow it to perform those tasks? And note, in deciding what an establishment is, it's not essential for each unit or entity to have independent management, or its independent legal, economic, or administrative or financial autonomy, and nor is it necessarily a requirement that there is geographical separation. That latter point almost infers the possibility that you have sort of two establishments on one site. So that is even open up for debate. I've not come across that argument before, and I was thinking about this last night when I was doing these slides, and as to what circumstances could this potentially apply. And I came up with Birmingham City Football Club, who I believe are sharing their ground with Coventry City. And if all the staff are working at one site, then potentially you could argue that although, if both Birmingham and Coventry were making redundancies and there was more than 20 at one establishment, you could argue that they are separate establishments, but we still have that argument that they are separate employers anyway, separate distinct legal entities. But I was just trying to think of a scenario where that would apply, and I was struggling to really find one. So what does this mean in relation to multi-site redundancies? So the Woolworths case confirms that there's no requirements to aggregate establishments as long as they are separate. I think it's important to, however, also bear in mind the possibility that it is still possible for a separate geographical location or multiple geographical locations to be one establishment. There's not been any case law on this particular point since the Woolworths case went through, and I would say practically both employers and unions tend to work on the basis that geographical location is a determining factor in being separate establishments. But I want to just be clear, don't make that assumption, take advice. And so there's two cases here which predate Woolworths, but which maybe just give you a feel for the potential arguments that could be raised. And the first one is Barrick Development's case. This was obviously a construction company where they had one head office from which everyone was essentially employed. Even the people working at sites were assigned to the head office, but they were mobile workers. And they had 14 sites where their building operations were presently being carried out. They were making more than 20 redundancies across those 14 sites, including head office. And it was held in that case that that was one establishment. The fact that the redundancies occurred across multiple sites didn't prevent the finding of one establishment. And a very similar outcome in the Clerks of Hove Limited against Baker's Union case. 28 retail outlets were held to be one establishment, despite geographical separation. This was outweighed by the common management and accounting approach for the retail outlets. Now, as I say, this is historical case law. Woolworths has probably made the arguments around geographical separation a lot more difficult for a union to run, but it's not beyond the realms of possibility. And I put the store locator on there for McDonald's, not because I love McDonald's, but because this could be a good example. Let's take Preston. I suspect in Preston, you've got anything between 3 and 4 McDonald's within a 5-mile radius, maybe 6-mile radius. And you may well have staff that are assigned to one of those stores within Preston, but with a mobility clause that requires them to work across any of the Preston stores. Add to that the fact that there will be a regional manager who is responsible for overseeing the management of those stores in Preston, perhaps also stores further afield. Then there could be an argument that if we're looking to make sort of a headcount reduction across the McDonald's estate, could all those stores in Preston be treated as one establishment rather than separate establishments? And that could be opened up for argument for a union to run. So I say the key point is don't make assumptions that geographical location is the answer to avoiding the obligation of collective consultation. I can see the unions at some stage trying to run some of these arguments, particularly where you have multiple stores in one city or town or within a very close radius. The next stage of the Section 188 test is that there's got to be 20 or more dismissals within a 90-day period. So firstly, what do we mean by dismissal? Well, the dismissal takes effect when the contract comes to an end. It is not when notice is served. So you need to have a look at when the employment will actually end rather than when you're going to serve notice in terms of when this falls within a 90-day period. The statutory trigger looks at a rolling 90-day period. Be mindful of staggered dismissals. I'll come on to staggered dismissals very shortly. And be mindful of future plans. What are the future plans for the business? Are there other plans for redundancies at other establishments, at other sites, in other parts of the business? And how advanced are those plans? Have they become more than just a formative plan to become actually a proposal? And if so, do they need to be factored into your thought process, to your planning? So by way of example, case study, an employer proposes to make 10 employees redundant on the 1st of July and gives them 1 month's notice on the 31st of July for their employment to terminate on the 1st of September. On the 28th of August, the employer then proposes to make 10 more employees redundant, all with a notice period of less than 4 weeks, the effect of which would mean that 20 people will have been dismissed within a 90-day period. The question is, are the regulations crystallized? Is the employer now obliged to consult with the first batch of 10, the second batch of 10, or both? And to answer that question, I think we need to have a look at the Transport and General Workers Union against nationwide haulage case. In this particular case, the case confirmed that the law does not apply retrospectively, such that an employer has to consult on dismissals that have already happened merely because further redundancies emerge. Now, that case would be relied upon to argue that that first batch of dismissals can be ignored. The dismissals or the notice of dismissals have already been served. Let's forget about the first batch of dismissals. We don't need to engage in 30 days consultation with them, but we do need to consider engaging in 30 days consultation with the next 10, because they would go into the 20 dismissals within a 90-day period. My concern with this particular case is that it is an old case, 1978, as you can see. It's not only an old case, it's only a first instance decision. It's never been challenged by anyone, so there's no Employment Appeal Tribunal decision on this. With it being a first instance decision, it does mean that any tribunal can come to an alternative finding and is not bound by the finding in this particular case. So my view on that scenario I gave you before, too late to go back and consult with those that we've already given notice of dismissals on. It almost feels like consultation would be pointless, and we'd rely on the national haulage case to try and defend any potential allegations that we've breached our obligations. We'd certainly consult with the second batch, as the extra 10 dismissals will trigger the 20 dismissals within a 90-day period. So we'd engage in 30 days consultation. However, there are some risks. If the first batch is still a proposal at the time that you start proposing the second batch, so we haven't actually effected redundancies of notice, then there might be an argument that we should consult with both batches at the same time for 30 days. There is also another risk that the union or the employee representatives argue that the employer always proposed 20 dismissals, but deliberately staggered the dismissals to avoid the regulations. And that could, if subject to, sort of any evidence to support that argument, that is certainly a potential challenge. And in that regard, if we were to become litigious on that particular point, bear in mind that the obligation of disclosure in tribunal proceedings is to disclose all documents that are in favour of your case, but also not supportive of your case. They've got to be all documents that are relevant, and typically what you will find in these scenarios are board decisions, minutes of board meetings, which document our thought process on our decisions about making proposals of dismissals. And it's that kind of information that the union will be seeking disclosure of. And if they get their hands on minutes which suggested that we'd always propose the second batch, then it's a slam dunk for the union. You've breached your protective, your consultation obligations for both batches, or certainly the first batch, and they would have a claim for a protective award. Case study 2. Again, this is about staggered dismissals. An employer has proposed 30 redundancies and has begun collective consultation with those people affected before it makes any decisions. It then proposes to make another 10 redundancies, which would take effect within the same overall 90-day period. Do the collective consultation obligations apply in relation to that second batch? Of course they apply to the first batch because we're over the 20, but do they apply to the second batch? And the answer to that is no. There is a carve out in the regulations, section 188.3, which says that when determining the number of dismissals proposed, no account is taken of employees in respect of whose dismissal consultation has already begun. So if we've already started that consultation with the original 30 redundancies, then we can disregard them when assessing whether the collective consultation obligations are crystallized for the next 10 redundancies. And they can now be viewed in isolation. So we would say no obligation to collectively consult with them. However, I come back to another point. It is still always open to the possible challenge from those 10 people that were made redundant, or the employees that were affected by those 10 redundancies in the second batch, to say that we think that the employer has deliberately split the employees into 2 batches in order to avoid the collective consultation with the second batch. And if that was the case, it would be liable for a protective award to the second batch of employees. And again, it comes to that point about what have you documented as a business around these decisions? Because if you've been documenting them and minutes in management decisions, minutes in board decisions, then those documents will be disclosable. What are they telling us in terms of when the decision-making process has been made? And it's quite just on this point. I've just, I suppose, emphasised the importance of the particular point. I had a conversation with a client yesterday who their business is currently looking at 70 plus redundancies at their head office, out of about 290 staff. They have started collective consultation, and now they are looking at the possibility of another 50 redundancies. And if those redundancies would take place potentially within the 90-day sort of period. And the question was whether or not the 45-day consultation obligation is crystallized, rather than the 30-day consultation for the first batch. Could we split into 2 and do 30 days consultation for each, or do we have to do 45 days for the second batch or 45 days for both? And our view on that is potentially 45 days consultation for both if we are still in consultation with that first batch. It's still a proposal, then there's no reason why the second batch couldn't be included. Next thing to have a look at is affected employees. So we've identified the need to potentially consult, and the obligations to consult with those employees that are proposed to be dismissed. And they are affected employees. But it's not just those that are at risk of dismissal. It's also those who may be affected by the measures in connection with the dismissal. Now, there is no definition in the legislation as to what the measures, what measures means. We expect it to be given some kind of wide interpretation, very similar to the meaning of measures within the TUPE regulations. And in the TUPE regulations, measures is essentially any action, step, or arrangement. So we take the view that measures would capture any new systems that you are introducing, any new way of working, any new hours or change to hours, any new arrangements in the way how people do their work, any reporting, any changes to the reporting structures or reporting lines, any new duties that individuals have to absorb. If it has affected another individual who remains employed in some way or another, then they are an affected individual. And this is important because when you're assessing liability, you need to understand that, sort of the protective award that would be pursued by a union or employee representative is a protective award for all affected employees, not just those that have been made redundant. So that initial example right at the beginning, 70 redundancies out of a headcount of 250, let's assume it's all 250 staff are affected in some way, shape or form by the changes that have taken place, then the potential liability for a protective award would be for all 250 staff. Now, the practical reality is that those staff that remain employed by you are unlikely, if there was a successful claim for a protective award, they are unlikely to enforce the protective award against you as an employer, as they wouldn't want to cause financial damage to you as an employer and potentially result in them being made redundant. But certainly the 70 people that have lost their jobs, they would have nothing to lose but to go ahead and enforce the protective award. The obligation to consult or to inform and consult is with appropriate representatives. What do we mean by appropriate representatives? Essentially, there are 3 categories. The first is a recognised trade union. To be clear, what I mean by a recognised trade union, it is a trade union that you have recognised either informally or formally for the purposes of collective bargaining and consultation. More often than not, employers will have in place a recognition agreement, a procedural agreement, or a collective bargaining agreement, which confirms the union status as the recognised union. Sometimes you will actually have more than one recognition agreement with more than one union, or more than one union on one recognition agreement. So you might have multiple trade unions that you have to consult with. Sometimes you may actually have no formal recognition agreements in place. It's all based on custom and practice. But if your custom and practice has been to recognise the trade union for the purposes of collective bargaining and also for consultation on key issues that affect the business, then there is an argument still that they are recognised for the purposes of collective consultation under the regulations. If there isn't a recognised trade union, or you have employees that are affected by the proposals but are not within the collective bargaining unit which the union are recognised for, then you will need to consider whether or not you've got employee representatives that are already elected for the purposes of collective consultation of the redundancy proposal. And if not, then you'll need to look at having elected employee representatives put in place for the purposes of redundancy consultation. It's very rare for employers these days to have employee representatives that are elected already before you start this process for the purpose of collective consultation. You might have a works council. If you do have a works council made up of employees, you need to see what the terms of reference are for that works council to decide whether or not that gives them the mandate to be involved in collective consultation on behalf of the staff they represent. So we'd have to have a look at the terms of reference to see whether or not that works council has that mandate. More often than not, we're in that scenario 3, where we're looking at electing employee representatives for a specific redundancy consultation exercise. And in terms of elections, the requirements for an election of employee representatives are set out in section 188A of the regulations. I don't intend to go into too much detail about them. Safe to say that you need to identify, the categories of workers that are affected, ensure that there is an employee representative for each category of workers that are affected, and that there is a proper nomination process where people get the opportunity to nominate themselves or other people to be employee representatives, and that there is a proper secret, wherever possible, ballot for the appointment of or the election of who the appropriate the employee representatives will be. Now, the case of Phillips against Exterior Communications confirms that you don't need to have a ballot where the number of nominees is equal to or more than the positions available. Sorry, it's equal to or less than the number of positions available. And that's quite a useful case because sometimes the election process or election of employee representative process can add on at least 2 weeks to your timetable for collective consultation. And if you work, depending on the number of people you employ, that could be an additional cost of sort of £100,000 plus. So maybe a strategic or a tactical approach is to ensure that you have enough employee or enough candidates or available positions for each category of workers so that the risk of having to go to a ballot is reduced. Example, let's say we have work categories of teaching staff, non-teaching staff, and management. So those are our 3 categories. We have 60 teachers, let's say 20 non-teaching staff, and 10 management. I would say go for 4 employee representatives for the 60 teaching staff, approximately 2 employee representatives for the non-teaching staff, and 1 or 2 representatives for the management staff. And the reason for putting the numbers higher is that if you don't get that number of, if you don't get more nominees than positions available, you don't need to go to the ballot. So you skip out the ballot process, you can move them straight to an appointment. So just think about that tactically as to whether that might save you some time, depending on the costs associated of extending the consultation process. If you are looking at, should just add in terms of elections, some clients like to cut corners. They like to do it very quickly because obviously time is of the essence. We do recommend a minimum 2-week period for a proper nomination and election process. If you cut that down, which some clients do, you are taking a risk that you are rushing this process. And a breach of the Section 188A regulations is a breach of your collective consultation obligations, which then entitles the union or the employee representatives to seek a protective award. So this is not just ancillary requirements. These are still fundamental requirements as part and parcel of the collective consultation regulations. So do not cut corners unnecessarily. It can create an unnecessary risk. Where we are looking at 20 or more redundancies, you must notify the Secretary of State using Form HR1. Know that a failure to inform the Secretary of State of collective redundancies is a criminal offence, which means that the employer will be liable on summary conviction to a fine of an unlimited amount. Certainly not something reputationally that a company would want. Where you're looking at 20 to 99 redundancies, then you should submit the HR1 30 days before the first dismissal takes effect. Remember, dismissal is not notice. Dismissal is when the contract ends. So if you're asking employees to serve their notice period, the dismissal will be further down the line. Or where you're looking at 100 or more redundancies, then it's 45 days before the first dismissal takes effect. You should also supply a copy of your Form HR1 to employee representatives. The form that the Secretary of State provides is very much geared towards it being a redundancy, redundancy scenario where people are losing their jobs. It isn't very well, it doesn't give you much flexibility or ability to change the contents of the form to cover a scenario of termination and re-engagement. And this can be a bit of an issue because when I was advising a school in relation to the sort of collective consultation process around termination and re-engagement of staff, we submitted the HR1 to the Secretary of State at the commencement of that process, and we issued a copy to the employee representatives. But the staff, it caused a massive issue with the staff because they thought that they were going to lose their jobs, they thought they were going to be redundant. And that's despite us wording the HR1 very carefully to try and make it clear that whilst we were looking at 20 or more dismissals, we were offering everyone a job still through re-engagement. So the impacts on morale that HR1 can have in that scenario can be quite significant, and it can get that consultation process off on the wrong footing. So communication to all your staff as well as your employee representatives is fundamental. So in terms of the consultation process, just take you through what this looks like. Firstly, well, it's sort of split into two key elements. The first key element is provision of information. And the second key element of this is consultation with a view to reaching agreement, an emphasis with a view to reaching agreement. So when does consultation start? Well, consultation period will start when you give the information. Information must be given after the election and appointment of employee representatives. It can't be done before. So you've got to get your employee reps into position. You've got to have the union on standby. We will then give the information. I'll come on to the prescribed information we need to give. The way the legislation works is the legislation works backwards from the date on which the first dismissal takes effect and examines whether or not consultation began sufficiently far in advance of that date, and as a minimum, the minimum 30 days or 45 days period has been achieved. So we're looking backwards, but typically what will happen is as soon as you've appointed the employee reps and you've got your union on standby, you'll issue the information letter to the employee reps and trade union. And that will start the consultation process. That will start the 30 days or the 45 days running. The requirement is to provide that information in writing. You can either deliver that written information personally to the employee representatives and or to the union appointed union, or by post. But if you're sending it by post, then you need to address it to the union's head or main office. It can also be good practice to ensure that you maybe adopt multiple methods of providing that information. So in addition to perhaps sending it or delivering it personally to the employee representatives at a meeting, you might want to send it by email to the union and to the employee representatives as well as a backup, and or put it in the post. I always think as well that when we're sending out this very first information letter outlining our proposals and the reasons for it, that it's probably good practice to send a copy to all affected staff for the sake of transparency. It just helps with the information flow and ensures that your staff know what's going on, and also ensure that your staff know that consultation has now begun and to start liaising with their employee representatives or their union. Section 1884 of the regulation sets out what information you need to provide in your letter. So you're going to have to set out the reasons for the proposal. And I would say that that first bullet point is the key point to get right. The more information you put in there about the reasons for your proposal, the business rationale for why we are proposing these dismissals, the easier it is for the employee reps and the unions to go away and think about it and come back and try to come back with solutions. What you don't really want to do is end up in a massive battle as to why are redundancies necessary. So let's put the effort in to the reasons for the proposal. We've got to outline the numbers and description of employees that we are proposing to dismiss as redundant. So we'll have to potentially look at it on a department by department basis or a category of worker basis and identify which categories of workers are affected or departments are affected and how many in each category are affected or that we propose may be affected. We'll need to identify the way in which we will be selecting people for redundancy, how the dismissals are to be carried out, taking into account any agreed procedures that you might have in place with the union, including the period over which dismissals are proposed to take effect. We should also outline the method, the method of calculating redundancy payments. Are we relying on statutory redundancy payments only, or is there a contractual enhanced redundancy pay entitlement that we should be working towards? So we outline how redundancy payments will be calculated. We also need to provide suitable information about our use of agency workers, and the reason for that is that may be part and parcel of the employee representatives or unions representations as to how redundancies can be avoided or the number of redundancies reduced. The use of agency workers can sometimes be a very contentious issue. So, excuse me, I mentioned before, it's really important to put a lot of effort into your business rationale. Not only do we need to demonstrate that there's a genuine reason for redundancy or these redundancies, but the more detail we put into the business case, then the smoother and more quickly consultation will take place. So what should be included? Well, I'd certainly set out the background as to the business, so its historical position. What has changed? How has this situation come about? What is it that's causing this particular problem currently in COVID-19? That's the problem, but just saying it's because of COVID-19 isn't sufficient. Let's give them more detail. What impacts has COVID-19 had on the number of sales that we're getting, on our income, on our cash flow, etc.? What are our forecasts in how long it's going to be until that recovery may come back round? So let's put more effort into that detail. What has the business already considered to avoid redundancies? So you may already have gone through a raft of cost-cutting measures which the employees might not be aware of. Let's give them all the information of all steps that we've already taken to reduce cost in the business. Because if you don't give them that information at the outset, they're just going to raise it in consultation. So let's get it out on the table. Let's be transparent. What is the proposal and why? What impact the change will have on the business? So how will the changes benefit the business? Are there any detrimental impact that the changes will have on operations? Let's be transparent. Let's look at the positives of the change in terms of cost efficiencies or reduced headcounts or reduced costs against the negative. Do we envisage any particular problem areas? And we need to be absolutely clear that our proposals are merely proposals at this stage. There may be changes which are subject to ongoing consultation. So if there are changes to our plan, our strategic planning, then we will need to update the information letter and notify the employee representatives and the union about those changes. And that will need to be subject to full consultation. But we also need to get the message across that our plans may well change because of consultation. So making sure that it's a two-way process and not just a a one-way process which points towards a decision. In terms of the consultation process, I use the acronym ARM, and there are 3 mandatory duties for consultation, and that is avoiding redundancies, reducing the number of redundancies, and mitigating the consequence of redundancies. The case of Middlesbrough, BC against TGUWU confirmed that those 3 areas are indeed mandatory obligations in terms of consultation. It confirmed that consultation must be meaningful with a view to reaching an agreement. It also made it clear that you've got to take on board any comments, suggestions and representations that you receive from the union and or the employee representatives. And more importantly, this should not be seen as a box ticking exercise. So just to go into a bit more detail about the Middlesbrough case, Middlesbrough Borough Council decided that redundancies were necessary in order to address a budget deficit. Because it began the consultation with a closed mind over the issue, the Employment Tribunal found that their consultation over ways of avoiding redundancies was a sham. Although the council had consulted about ways of reducing the number of employees to be dismissed and mitigating the consequences of the dismissals, the failure to consult at all about ways of avoiding dismissals meant that the council was in breach of its collective consultation obligations. The EAT upheld the tribunal's decision and confirmed that it is no defence to argue that consultation would have made no difference. So I think the point in relation to this is that it's very easy to consult on reducing the number of redundancies or mitigating the consequences of redundancies. The real challenge for employers is ensuring that you start consultation early enough so that you can meaningfully consult on avoiding redundancies. If you have allowed your proposals to gather so much momentum that you're putting forward proposals such that dismissals cannot be avoided, then there is an argument that you've breached your obligations, and again, could be something that the union decides to litigate over. Now, in terms of what you consult on, we need to consult on the reasons for redundancy. This is based on the leading authority of UK Coal Mining Limited 2008. That related to the closure of a mine, which resulted in redundancies. And the case centred really around when consultation should have begun. The argument from the union being that the decision had already been made to close the site, that the employer should have been consulting with the union and the employee representatives about a proposed site closure rather than simply making it as a fait accompli. And because they failed to do so, they were in breach of their obligations, and the courts held that there was indeed a breach, and in particular that there is an obligation on an employer to consult on the reasons for redundancy, which extends to the proposal to close a site. You mustn't allow your plans to get to a point where you've already made that decision, and which will result in dismissals, because you will not have consulted on avoiding dismissals. So as soon as you start thinking that a potential outcome is a site closure, you need to start thinking we need to be consulting with the unions or employee representatives to ensure that they have at least the opportunity to come up with ideas, solutions, or proposals as to how that site could be kept open to save jobs. So how long should consultation last? Well, the guidance or the regulations talk about 30 days for 20 to 99 redundancies and 45 days for 100 plus. But actually, when you look at the wording of the regulations don't actually stipulate that consultation must last 30 days. It merely says that consultation must begin in good time and at least 30 days before the first dismissal takes effect. What do we mean by the first dismissal takes effect? I mentioned before, we're talking about when the employment contract comes to an end. So it is perfectly possible that, number one, consultation may be shorter than 30 days or 45 days. And if indeed, let's say you've done 20 days consultation and the union saying there's nothing else to discuss, then there is nothing preventing you from issuing a notice to dismiss at that point in time, as long as the dismissal does not take effect before the 30 days is up. If it takes effect, so the notice period runs beyond the 30 days or the 45 days, then you will not breach the regulations. The key thing is that you have completed consultation and that the parties, the union and the employer, agree there's nothing else to consult about before you issue notice of dismissal. The other key point about this is that this 30 days and 45 days time reference is a minimum time reference. Just because that is the number of days allocated doesn't mean that it is sufficient for meaningful consultation to take place. Remember, the regulations are about meaningful consultation, and therefore you need to allocate sufficient time to be able to fulfill that obligation. And I'll come back to this school example with the pension changes. There was absolutely no way we could get through consultation in 30 days on such a complex issue. There were only 60 plus staff affected, so we could have got away with 30 days consultation if we took the regulations at face value, but we wouldn't have engaged in meaningful consultation. And therefore, we've actually extended consultation for a period of nearly 9 months, given the complexity of what the issues are. Had we stuck to the 30 days, I am absolutely certain that the unions would be bringing a claim for a protective award for a failure to inform and consult properly, not because of the 30-day issue, but because it wasn't sufficient time to consult properly. The case of Junk against Connell, which is actually a European Court of Justice case, has confirmed that notice to dismiss may be served during the 30-day or 45-day period, or before it expires, as long as the effect of the notice doesn't result in the dismissal occurring before those time periods have passed. And that quite, so most of the clients that I speak to will always work on the basis that they won't effect notice of dismissal until the 30 days or 45 days is up. So it's a common misconception that you can actually serve notice before it's up, but just that the dismissal can't take effect before it. Now, you'll have heard me talking about a protective award quite a lot in terms of a failure to comply with the collective consultation obligations. I just want to be clear as to what the potential consequences are of a failure to comply. The first thing is that the union and or the employee representative can bring a claim. It is them that will bring a claim on behalf of the group of employees, not every, so you don't require each individual employee to bring their own claim. They will bring a collective claim on behalf of all the employees that they represent, and any award will apply to all those people within that affected group. And if they are successful, the tribunal will give a declaration about the failure to comply with the regulations, and in particular what parts of the regulations it fails to comply with and why. And they will then determine what protective award should be given. In addition, the potential consequence of non-compliance is, does it render the dismissal of the individuals unfair? Well, there's nothing in the Employment Rights Act that says that it renders the dismissals automatically unfair, but it is certainly a factor that could be taken into consideration as to the overall fairness of the individual dismissals. So a non-compliance with collective consultation completely might mean that your individual dismissals are subject to a greater risk of being found to be unfair. And again, I mentioned before, it's a criminal offence not to serve Form HR1 as well. The other thing, whilst we're talking about unfair dismissal, is, in fact, I'll come on to that in a moment. I believe it's on the next slide. So, in terms of the protective award, the maximum protective award is 90 days pay for each dismissed employee or each affected employee. Remember, affected employee extends to those not necessarily dismissed, but those that are affected by measures. The statutory cap on a week's pay does not apply. So it's not subject to the same cap on a week's pay for redundancy purposes. It is their gross weekly pay. It's designed to punish the employer. That's based on the Susie Redding case I mentioned earlier. So it's a sanction on the employer. And what the tribunals will do is they will look at the severity of the breach of the regulations, and they will decide what is just and equitable having regard to the severity of that breach. So an employer that completely fails to engage in meaningful consultation. So let's say they've predetermined, some disclosure occurs which shows that the decision was set in stone, it's predetermined, and it's been a box ticking exercise. In those circumstances, you could expect the award to be 90 days pay because the whole consultation process was a complete sham. However, let's say an employer has breached technically the obligations around ballot, election and balloting, but ultimately there were still employee representatives appointed. We engaged in 30 or 45 days consultation. We might have saved a few redundancies as well. Then you would hope that a tribunal would say, well, we've complied with the majority of our obligations. We've just had a technical breach. So any award might be 1 or 2 weeks gross pay. But as I said, the starting point is 90 days pay, and then they'll look at, is there any reason why it should be less? Look having regard to all the circumstances. Remember, employees do not need to have been dismissed to be entitled to a protective award. The commercial reality, as I mentioned earlier, is that more often than not, it's the employees that have been dismissed that will seek to enforce the award. And those employees that remain employed, you would hope to persuade them not to enforce the award. So the way it works is the union or the employee representatives will get a protective award, which covers all the affected staff, and the staff will be named in a list of names, and they will then have the right to enforce that award against the employer. So obviously you've got an opportunity to persuade all your existing staff not to enforce the award, because to do so would be financially crippling. But whether they choose to agree to that or not is down to sort of your relations with your employees at that point in time. And I come back to that point. This protective award typically can be really, really expensive. We're usually talking, in the £500,000 minimum up to millions of pounds of potential liability. So compliance really is important. In terms of unfair dismissal, the old historical case of Williams against Compare Maxim, 1982, which still regulates what a fair redundancy dismissal looks like, makes it clear that collective consultation has a part to play in a fair dismissal. In particular, giving unions and employees as much warning as possible of the possibility of dismissals and the reasons behind it, which comes back around to that information obligation. Agreeing with the union selection criteria for redundancy, a failure to consult at all, or a failure to consult over critical matters which could have made a difference or could have saved jobs, might also be issues that are pulled up to try and argue that any dismissals are unfair. I think the sort of key point here is you have an opportunity through collective consultation to narrow the issues that you need to engage in individual consultation. So collective consultation does not mean you don't need to engage in individual consultation. You've still got to engage in individual consultation. But if you address some of the areas that would be subject to individual consultation, such as the criteria for selection for that particular department and how the scoring is going to take place, and other ways and means of avoiding dismissals, sort of through the cost-cutting measures, then that basically reduces the amount to consult with over the, over the individual, over their individual circumstance. And really, you're limiting what you're going to be talking to them about in terms of suitable alternative employment. So the more effort you put into collective consultation, the easier individual consultation is likely to be. And there is nothing to stop you commencing individual consultation whilst collective consultation is ongoing. For me, the key is timing. Certainly you could have a first individual consultation meeting with all affected individuals just to tell them about the fact that their roles are at risk of redundancy, but we're subject to collective consultation, but we wanted to get a feel from them as to any ideas or suggestions they've got around avoiding redundancies, etc. That's perfectly permissible, but don't allow individual consultation to progress into potential selection until the latter stages of your collective consultation period, because once you start selecting people for provisional redundancy, there is an argument that perhaps the outcome of dismissals is a fait accompli, and therefore consultation is meaningful. So you don't want the progress you make with individual consultation to undermine the meaningfulness of collective consultation. Are there any defences? There are. The first one is if you have a workforce that doesn't recognise the trade union, and despite inviting employees to elect employee representatives, they have failed to elect employee representatives, then your only obligation is to provide them with information. However, you still have the obligations of individual consultation, etc. But if they fail to elect employee representatives, then all you do is provide the information to all affected employees, and that's it. You do not need to engage in consultation thereafter because there's no one to consult with. Very, very rare circumstances that I've never seen it before. The other potential defence is what's called a special circumstance defence. And that's where there are special circumstances which rendered it not practicable or reasonably practicable for the employer to comply with their requirements under the regulations, and in particular to begin consultation in good time and at least comply with the minimum period before the first dismissal, or to consult with a view to reaching agreements about ways of avoiding dismissals, reducing the number of dismissals, or mitigating the consequences of dismissals. I think it would be fair to say that reliance on the special circumstance defence is really, really difficult. It's actually called the we call it an exceptional special circumstance defence because it is so exceptional that tribunals will entertain it. An insolvency of a business is not necessarily sufficient to be a special circumstance defence to not consulting with the staff. And the reason for that is usually employers or the organisation or the directors know that the business is moving towards an insolvent position and should have started consultation earlier. The reason they haven't done is because they didn't want to disclose the financial position to the staff, which would then potentially affect their reputation or create a snowball effect or scupper any possibility of a rescue deal. So in those scenarios, tribunals have been very unsympathetic to that argument and have said, no, sorry, you don't fit in with the special circumstances. So please don't expect to rely on this defence. It is exceptional. There was one case in the Clerks of Hove against Baker's Union case where the court gave an example, and that where they talked about a sudden disaster which strikes a company, making it necessary to close the business down with immediate dismissals. That could be a special circumstance defence, but it must be something out of the ordinary. Insolvencies are not out of the ordinary. And finally, coronavirus and collective consultation. I think I had some clients who were going through collective consultation a couple of months ago when the lockdown restrictions were still in place, and therefore there were issues on how you can collectively consult properly and meaningfully when you can't get round the table with union representatives and employee representatives. But ACAS have produced a updated guide in terms of making redundancies, which covers dealing with redundancies during coronavirus, and essentially they seem to be promoting the use of video technology to ensure that those meetings take place regardless, to ensure the provision of information and transfer of information between the parties. And it seems to be that that's perfectly acceptable way to inform and consult with employee representatives and the trade unions. Indeed, I've been engaged in the consultation meetings with the union on the school pension changes, and we held multiple Zoom meetings in order to achieve that. So it is still possible. I think the thing you need to be thinking about, if we've got lockdown restrictions, which means we can't get around the table, is really making sure that the employee representatives have access to all the information they need, that the employees that are affected have transparency in what's going on, and that they also have access to the employee representatives, and that we facilitate that access to take place in some way, shape or form, whether it's through video calls or telephone calls, etc. That we ensure that the video meetings are meaningful and that we cover all agenda items, that we are sharing screen, screen share, with slides and financial information, whatever it needs to be, so that we are not sort of cutting any corners. The other point about coronavirus, our furloughed employees can be made redundant whilst, despite the fact that they've been furloughed. So there's nothing that prevents you from making people who've been furloughed redundant. That's been confirmed by HMRC. I think there was a bit of a hoo-ha in the press about a month ago. I think the Times reported that those that have been furloughed, because we're changing the third Treasury direction, that essentially meant that employers could not be made redundant if they'd been the beneficiary of a grant under the furlough scheme. That's not the case. We can make them redundant. Indeed, the Treasury direction and the guidance from the government also confirms that employees can serve their notice period whilst on furlough. And the guidance also confirms that employee representatives can fulfil their duties whilst furloughed and aren't required to be paid anything more for the work they do, as long as the national minimum wage is complied with. And the other thing just to point out is, whilst we can ask the employees to work the notice during furlough, we can't make a payment in lieu of notice and claim that back on the under the CJRS. The reason being is employees have to serve their notice period on furlough to be eligible to get the grant. And nor can we obviously claim any grant towards a redundancy payment, which I think is self-explanatory. So in summary, I'm pretty much bang on time. Plan and prepare. Take legal advice early on. As soon as there is a need to reduce costs, which is likely to result in redundancies, and possibly more than 20 redundancies, start taking legal advice. Let's start thinking about, when does that obligation to consult crystallise? Let's not leave it too late and leave ourselves open to challenge. When we start the consultation process, let's be transparent and authentic. I think if we are transparent and authentic as an employer, you are far more likely to get the buy-in of the union representatives, the employee representatives, and the staff themselves. And hopefully, you will also find solutions to some of the problems you've got. And even if you can't avoid redundancies, you might reduce the number of redundancies. Good example, I was acting for a retailer, and they had to make headcount reductions of about 4 people per store. And I was speaking to one HR business partner for the particular region he was looking after, and we're talking about how we achieved the reduction in labour hours. And I said, look, rather than looking at it as a headcount reduction, let's look at it as a labour hours reduction. Let's talk to the staff collectively and see if they're prepared to share the burden between all of them. And I believe out of about 25 stores in his region, only one store, about 24 stores, all agreed to reduce their hours by the relevant amount, pro rata amount, to achieve the labour reduction in hours that they needed, and avoid redundancies completely, which is fantastic. So don't underestimate the power of consultation. Don't underestimate the loyalty and commitment of your staff to agree to changes which might be detrimental to them, but to help the business out and to save their job. And don't predetermine the outcome. Start with an open mind and consider all alternative options. So that's it from me. I appreciate there was an awful lot to get through. And I suppose has anyone got any questions that they would like to throw at me?
Emma has a question on behalf of a client, Ollie. And
okay.
The question, where in the home working group as a single establishment for collective consultation purposes?
Could you just repeat that question? You broke up right at the beginning.
Yes, sorry. Where a business has home workers, would you suggest treating the home working group as a single establishment for collective consultation purposes?
That's a very good question. I would probably say yes, because I think it's going to be very difficult to say each individual worker's home is a separate establishment. They will be controlled, managed by one establishment, let's say head office. They will be subject to the legal, financial, and accounting systems of that one establishment as well. So I think there's a big risk there that will be treated as one establishment, and we'd have to collectively consult with all the home workers. And I come back to this point is, if we're talking about 20 to 99 home workers that need to be made redundant, we're talking about 30 days consultation. And whilst that is a cost to the business of a month's wages for all your staff, or all the staff that you may have been able to make redundant, it's better than the potential liability of a protective award. And secondly, you can use that collective consultation to really iron out the issues and minimise the amount of individual consultation required afterwards. And further, you might be able to start that individual consultation partway through the 30 days. So better err on the side of caution and treat it as one establishment as opposed to a separate establishment.
Thanks,
okay.
That's all the questions.
Okay, does anyone else have any questions? If you do, raise your hand or email Kane with the query. No, rather a quiet group, perhaps information overload, I don't know, but I hope that was useful. I'd like to thank you all for joining us today. We will be making this this webinar available for all our HR3 clients, including yourselves that have attended. So you'll be able to share it with your colleagues where appropriate. And for those that are not clients, we will be making the link available for purchase. So please, if you've got any queries, by all means email me separately, but otherwise good luck, and if you need help, you know where we are. Thank you.